Good afternoon, everyone, and welcome to this month's People Hour session. For those of you who haven't attended People Hour before, every month we focus on different employment law topics, which we aim to complete within an hour. As always, you can ask questions as we go along using the questions facility, which appears on your screen during the presentation. However, we have got a fair amount to cover today, so I may need to deal with questions at the end. If we don't have time for me to deal with questions, then I will pick up separately with you after the webinar, or of course you can speak to your normal gunnercooke contact. So in today's session, we're going to look at some of the issues surrounding sickness absence dismissals. Certainly I find with my clients, managing sickness absence is always high on the agenda. So I thought it would be useful to run through some of the trickier issues in today's session. I'm going to look at three main questions today. The first is, what grounds should you rely on to dismiss an employee for short-term absence? Is it always a capability issue, or should you be relying on other reasons? As we know, getting the reason right can be central to establishing a fair dismissal for unfair dismissal purposes. Secondly, I'm going to look at when it is reasonable to dismiss an employee on long-term sick leave whose prognosis is uncertain. In particular, we've seen a recent Court of Appeal case which has given some helpful guidance on when to dismiss an employee in this situation and on just exactly how long you need to wait when you're in that situation where the prognosis is uncertain. And finally, I'm going to look at some steps to reduce the risk of when you're dismissing an employee who has a disability. In other words, are there additional steps over and above a fair procedure that you should take before dismissing someone if they have a disability? So first off, I thought it'd be interesting to look briefly at some facts and figures about sickness absence. According to the CIPD's annual survey report on absence management for 2016, the average cost of absence per employee is £522, or £835 in the public sector, and the average level of absence is 6.3 days per annum, which is actually the lowest it's been for a number of years, but clearly it's still a significant cost and a significant figure. The average number of days is significantly higher as well in the public sector, in manual jobs and in larger organisations, which I'm sure is no surprise to many of the listeners out there today. The CIPD's analysis is clearly only indicative. However, as it is based on replies from 1,091 organisations across the UK and in reference to 3.8 million employees, clearly it is quite a good indicator. So while sickness absence appears to be decreasing, the cost is still significant, and this clearly puts into the context the need to manage sickness absence effectively, so I'm sure you're all aware. In terms of the top causes of sickness absence, both long-term and short-term, these include stress-related absences, mental ill health, back pain, and musculoskeletal injuries. Additionally, for short-term absences, minor illnesses, which are often suspected to be malingering, of course, feature as number one. So stress-related illnesses is right up there in both categories, and is, of course, one of the trickier areas to manage. So looking first at what grounds you should rely on to dismiss an employee for short-term absence. I'm sure, as most of you are aware, when looking to dismiss an employee, the starting point is to establish a fair reason for dismissal. And as you may be aware, there are 5 potentially fair reasons for dismissal. The ones that are relevant here are conduct, capability, and SOSR, or some other substantial reason. When we talk about capability in this sense, we talk about an incapability to do the job due to ill health, and not poor performance, which is the other category within capability, which is frequently relied on when an employee isn't performing the job. So the significance of identifying the correct reason for dismissal is that if you get the reason wrong, it can lead to a finding of unfair dismissal. This is particularly as the procedure that needs to be followed is different for conduct and capability dismissals, Obviously, typically for conduct, you follow a disciplinary procedure, whereas capability dismissals are dealt with in a softer way, often by reference to a capability procedure. So if the wrong procedure is followed, it follows that the dismissal may be unfair. What is clear is that not all short-term absence dismissals will be by reason of capability, in other words, ill health. And I'm going to look at three main areas. Where the absence is not genuine, or this is suspected to be the case. Secondly, where the absence is genuine, but there is no underlying condition, i.e. short-term, intermittent, unconnected absences. And finally, where there is an underlying condition. So looking first at non-genuine absence, if you're dismissing an employee due to absence which you believe is not genuine, this will not be a capability issue because you're not dismissing them due to their ill health. The reason for dismissal in these circumstances that you would rely on is conduct, as the dismissal relates to the conduct of the employee. It will usually amount to misconduct or gross misconduct for an employee to dishonestly take sick leave when they are not genuinely unfit for work. However, before you make a decision to dismiss, as is always the case with conduct dismissals, you must have reasonable grounds based on a reasonable investigation to believe that the employee is not genuinely ill, and that can be very tricky. Clearly, it needs to be more than just a suspicion that the employee is swinging the lead or pulling a sickie, so to speak. One of the issues that sometimes comes up is whether it's possible to look behind a sick note if it's believed that an employee is not genuinely ill. My view is that this is a tricky issue, and whilst it isn't impossible to look behind a sick note, the evidence that the absence is not genuine will need to be pretty compelling if you're going to do so. However, it is helpful to see that in the case of Perry and Imperial College Healthcare NHS Trust in 2010, the EAT did rule that it is possible to say that a sick note is not necessarily conclusive evidence of sickness. In that case, sorry, I'm referring to the wrong case there. The case I need to refer to is Hutchinson and Enfield Rolling Mills Limited, just to keep you on your toes there. So in that case, that was the case where it was said that a sick note is not necessarily conclusive evidence of sickness. And in that case, the claimant was seen by one of the directors of the business during working hours attending a demonstration at a trade union conference. On that day, the claimant had obtained a medical certificate signing him off work with sciatica for 7 days. He was dismissed on the grounds that if he was fit enough to attend a demonstration, he was fit enough to work. The tribunal found that his dismissal was unfair, ruling that it was not reasonable for the employer to go behind the sick note. But on appeal, the EAT said that this was a total misapprehension and remitted the case back for a rehearing to a fresh tribunal. What the EAT said is that if employees are doing things away from their business which suggests that they are fit to work, then that is a matter that concerns the employer. And therefore it was legitimate for the employer to look behind the sick note and consider what the employee was doing whilst off work. So what if an employee has been working whilst on sick leave? Well, it's going to depend on the circumstances as to whether this is a conduct issue and also whether it warrants dismissal. In the case of Perry and Imperial College Healthcare NHS Trust, that was one case where it was found to be unfair to dismiss an employee where she had been working whilst on sick leave. And in that particular case, the employee worked as a community midwife and her job was active and involved cycling to patients' homes and climbing stairs, etc. She had a knee condition and was signed off work and received statutory and contractual sick pay. However, while she was off sick, she carried on with a second job for a different NHS trust, which was desk-based and therefore not affected by her knee condition. The second job was carried out one evening per week and therefore did not overlap with the hours which she worked in the first job. And Imperial also knew about the second job, but had not specifically consented to her working in the second job while she was on sick leave. The EAT in that case said that it had been wrong to characterise her conduct in claiming sick pay as fraud and that her dismissal was unfair. But I think it's very clear in that case that the employee already had a second job and the second job was not encroaching on her working hours during the first job. So you can see how in that situation there could be a finding of unfair dismissal. It may also be relevant to consider if the second job has some form of therapeutic value, which could not be obtained from the first job from which the employee is absent. So in the case of Calderdale Metropolitan Borough Council and Barnforth, the EAT acknowledged that a second job carrying out bar work may have had some therapeutic value for an employee who was suffering from a stress-related condition. Difficult to see how that's the case at first sight, isn't it? An evening job with bar work having therapeutic value. But I think it shows that employers should not discount that possibility, as clearly the EAT was willing to consider that it may have had therapeutic value. So in summary, I think it's important to assess all the circumstances. Clearly, there are likely to be reasonable grounds, certainly for disciplinary action and probably for dismissal, where an employee is receiving sick pay and is surreptitiously working elsewhere during his normal working hours. So he's actually gone and got another job whilst he's supposed to be off sick during a period for which he's being paid sick pay, as he's being paid twice for the same hours. That's a fairly obvious example of when it would be a conduct issue. So what about other activities on sick leave? Well, as I'm sure most of you are aware, there's no legal requirement for an employee who's signed off on sick to be sat at home the whole time. I imagine we've all seen cases where employees who are on sick leave have been found to be posting pictures themselves on Facebook on a night out, having a great time with all the mates. But for minor short-term absences, this could well be evidence of non-genuine absence. But it is important to avoid making snap judgments and to properly investigate. For longer cases involving longer-term illnesses such as stress-related illnesses or depression, it might of course be advisable for a worker to try and undertake activities that will promote their return to good health and work, such as social activities, leisure activities and holidays. And this of course should be considered in the circumstances. So I think there is a distinction there between minor illnesses where the employee has the odd day off when you wouldn't expect them to see them out and about and socialising possibly, and with the longer term illnesses where it's likely to be reasonable for the employee to participate in social activities, etc. So if you do have concerns about whether or not someone's conduct during sick leave suggests that their absence is not genuine, it might be a good idea to obtain a report from occupational health or another suitably qualified professional. Clearly, this won't be appropriate for one-off short-term absences, but where there is a pattern of absence, they may be able to comment on whether they consider the employee to be genuinely sick or if there is a degree of exaggeration. And if there is a degree of exaggeration, then it may well be that you could pursue that as a disciplinary issue. Clearly, if it's a case of misconduct, then the proper procedure to follow is your own disciplinary procedure and, of course, also the ACAS guide. So, moving on now to genuine short-term absences. So this is where you're not contesting that the employee is genuinely ill, and which are for minor and unconnected reasons, i.e. where there is no evidence of an underlying medical condition. So looking again at the reason for dismissal, this type of situation can be categorised as a dismissal for capability or as a dismissal for some other substantial reason. And it can be a bit of a grey area as to which is the right reason to apply. Some of you will be familiar with SOSR or some other substantial reason as the sort of sweeping up category that applies to certain dismissals where the other fair reasons do not apply. To amount to a SOSR dismissal, the key is that the reason relied on must be capable of justifying a dismissal. So clearly it can't be any reason. It has to be something which is sufficiently serious so as to justify dismissal. Typically, where an employee is being dismissed for short-term absence, it will be as a result of a failure to meet attendance targets, which triggers warnings resulting in dismissal. And where the focus is on a failure to meet the required standards of attendance, the correct characterisation will usually be SOSR. This is because the employee is being dismissed because they are regarded as not meeting the required standards of attendance, rather than as being regarded as incapable due to ill health. And of course, in many cases, the employee isn't incapable due to ill health. When they are in, they can do the job. It's just the fact that they cannot be relied on to meet the standards of attendance which are required. So it's only in this situation where ill health is at the forefront of the employer's mind that the reason for dismissal is likely to be capability. And really, in my view, that's only likely to apply where there's some sort of underlying medical condition, which I'll go on to in a minute. However, as it can sometimes be a grey area, if it comes to a tribunal claim, it is sensible in practice for employers to, or their lawyers, of course, to do what's known as pleading in the alternative. So relying on both capability and some of the substantial reason as the reasons if it comes to a claim. And that can often be done in this situation because the procedure which is followed is largely the same whether you're relying on some of the substantial or capability for these short-term, minor and unconnected absences. So what process should you follow in dealing with short-term unconnected absences? Well, I think most of you will be familiar with this type of process, certainly if you have a written absence management policy with trigger points in it, etc. So the process will be to review the patterns of absence and the reasons for them, to allow the employee the chance to make representations, to warn the employee of the required improvements in attendance that are required, and specifically the period of time over which those improvements are required. And then if the improvements are not met, if the requirements are not met, then it's moving to dismissal. One of the key questions is whether or not you need to obtain medical evidence where you're dealing with unconnected minor absences. And there's a case from 1998, Lincock and Serial Packaging, which says that really when you're dealing with short-term unconnected illnesses, there's little purpose in obtaining a report where it's clear there is no underlying health condition to investigate. That said, I think it's really important to be confident that there is no underlying health condition, and obtaining a medical report can help to rule that out. At the very least, you should ensure that you fully consult with the employee about the reasons for their absence so that they have the opportunity to disclose any underlying condition. Conditions such as ME, for example, can manifest themselves in seemingly minor unconnected illnesses, and it may not be obvious that an employee has an underlying condition until it's investigated. So in other words, don't sort of stick rigidly to your absence management policy without considering if there is an underlying medical condition. Obviously as well, additionally, as you can discriminate against an employee when you're on notice of a disability through its symptoms, you would at least need to satisfy yourself that there is no underlying health condition which might require reasonable adjustments before adopting the relatively straightforward procedure on the slide. So this brings us on to the situation where an employee is frequently absent for short periods due to an underlying condition. Well, in these circumstances, I think it's clear that the dismissal will be by reason of capability. The process to be followed here is similar to that you would adopt for managing long-term ill health, as is set out on the slide. The critical extra step from the procedure we've seen before is obtaining a medical report, either through occupational health or the employee's doctor or consultant, to ensure that you have an understanding of the employee's condition and the prognosis. So it's unlikely to be fair to apply trigger points rigidly where there is an underlying medical condition without considering first the prognosis of that condition. For example, will they make a recovery leading to an improvement in their absence levels, meaning that it's unfair, therefore, to apply a formal warning to them. It will also obviously be important to consider disability status and reasonable adjustments at this point. So moving on now to dismissals for long-term absence and when it's reasonable to dismiss. It's fairly well established through case law that a fair dismissal due to ill health will involve the following. Firstly, ascertaining the up-to-date medical position. What's the prognosis and what is the diagnosis? When will the employee be fit to return? Will there be any limits on their capabilities when they return? Should any changes be made to accommodate their return? Next, consulting with the employee. So asking what is the nature of their condition, gaining an understanding from them as to what the effects of their condition are. What treatment have they received for their condition, or how do they manage it? What can they and can't they do at work? And do they agree with the medical report? So it's really important that you have that in-depth discussion with the employee and don't simply rely on the medical position and accept that without discussing with the employee whether they agree it's the case. If the employee is unable to return to their job, it's important to consider alternative employment. Also, considering any adjustments which would help them back to work. Because whilst technically there isn't a duty to make reasonable adjustments where an employee doesn't have a disability, it all goes towards reasonableness. So offering a phased return or a reallocation of duties in the short term is likely to be something that it's reasonable to consider in the overall context of a fair dismissal. The final point is to consider if it's reasonable to wait any longer for a return to work. And this is particularly relevant where you are unsure as to the prognosis and it's unclear as to when the employee is likely to be able to return. So this is going to be very much a fact-sensitive question based on the nature and context of the employee's job and illness. It has been established through case law that the following factors may be relevant as to how long an employer may be expected to wait. Firstly, the availability of temporary cover and its cost. Secondly, the fact that the employee has exhausted his sick pay, although notably, and particularly with very generous or rolling sick pay schemes, it can be fair to dismiss even if the employee has not exhausted his sick pay, if it's clear that they're not going to be able to return within a reasonable period of time. Next, the administrative costs that might be incurred from keeping the employee on the books. I can't think of any very obvious administrative costs which you might incur, and I think it would take some convincing of a tribunal to be able to show that that was the case, particularly if you've considered the cost of temporary cover separately. The size of the organisation, this is always a relevant factor in assessing the reasonableness of any dismissal. One that I would also add there is the impact on the organisation. So how is it impacting on fellow employees? Is it causing issues with team morale? Is there an issue with employees not being able to cover the work that this employee does, for example? And finally, it would be important to look at the prognosis of any medical report. So if a medical report states that a return is imminent, or the employee should make a recovery, for example, after an operation in the near future, then you're likely to be expected to wait. So what about a situation where you haven't been able to obtain a clear medical prognosis, or the prognosis is uncertain? Well, the recent Court of Appeal case of O'Brien and Bolton St Catherine's Academy, which came out in 2017, I think it was literally within the last month, has given some useful guidance in this regard. Mrs O'Brien was head of department at Bolton St Catherine's Academy, and she'd been on sick leave for over a year when her employment was terminated on the grounds of capability. So it's clear that her employer had waited for a significant period of time before moving to termination. What had happened to Ms. O'Brien is that she'd been assaulted by a student, resulting in a long-term absence for stress. A significant factor in the decision to dismiss her was her uncertain prognosis regarding a return to work. Her employer had requested information from her about her prognosis, but did not receive a satisfactory response from her. Ms. O'Brien was evasive, suggested that her GP should be contacted, but the GP simply directed her employer back to Ms. O'Brien for information, which she did not provide. So she was dismissed on the basis that the employer had done all they could do to try and find out the prognosis, but in the absence of any clarity on it, they were entitled to move to dismissal. However, at her internal appeal hearing, Ms. O'Brien produced a fit note from her GP saying that she was now fit to return to work, and she also produced a letter from her psychologist saying that she would make a full recovery following a course of treatment. The appeal panel found that this evidence was unclear and also contradictory with the evidence they had gathered during employment, and rejected her appeal against dismissal. The tribunal decided that the dismissal was unfair, and this was upheld all the way through to the Court of Appeal, although it did describe the decision as borderline. So the finding of unfair dismissal hinged on the fact that it had been unreasonable for the employer to disregard medical evidence at an internal appeal hearing that the employee may be fit to return to work. Also, it was found that as the employer had tolerated the employee's absence for 14 months already, it was unreasonable for them not to wait a few months longer so that they could obtain their own medical evidence. So in a way, the employer almost shot themselves in the foot slightly by waiting for so long in the first place, it could be argued. Looking at the case, some very useful observations were made by Lord Justice Underhill, which are actually useful to employers. He said, firstly, the argument, give me a little more time and I'm sure to recover, is easy to advance, but there comes a time when an employer is entitled to some finality. That is all the more so where the employee has not been as cooperative as the employer had been entitled to expect by providing an up-to-date prognosis. So this is clearly helpful in giving employers guidance that they are entitled to expect finality, particularly where there is no clear prognosis and the employee has been uncooperative. He then went on to say that no matter how obvious it seems, employers must provide evidence on the impact that an employee's continued absence is having on the organisation in order to justify dismissal. He said, in principle, the severity of the impact on the employer must be a significant element in the balance, and it is not unreasonable for a tribunal to expect some evidence on that subject. What kind of evidence is appropriate will depend on the case. Often, no doubt, it will be so obvious that the impact is very severe that a general statement to that effect will suffice. But sometimes it will be less evident and the employer will need to give a more particularised evidence of the kinds of difficulty that the absence is causing. So whilst in some cases a general statement may be enough, in others it will be less apparent. And I think the lesson to take away is that you will need to be able to provide specific evidence of the impact. Such evidence may be who has been brought in to cover the work, the additional cost to the business of doing so, how duties have been reallocated to colleagues, for example. And including this information in the dismissal letter is a good way to present this evidence and to show the impact of the absence has been considered properly by the dismissing officer. So this case also highlights the danger of ignoring evidence regarding fitness for work when new information is produced in an internal appeal. Medical evidence clearly must not be ignored, even if it's produced at the last minute or if it seems to be contradictory. If new evidence is produced, further investigation should be made by an employer's own occupational health or by external medical advisors. So the final question that I'm going to look at today is how you can reduce the risk of dismissing an employee with a disability. Now this is a huge topic in itself, disability discrimination, so I'm not proposing to look at it in significant detail. What I'm going to focus on in particular is looking at reasonable adjustments and also having a look at discrimination arising from a disability and proportionality. So in terms of dismissals related to a disability, this will apply equally to long-term absences and to intermittent absences caused by disability. In relation to the process, well, the process to be followed is largely the same as for managing long-term absences, but with the added step of considering disability status and reasonable adjustments. I would also add to that where you are dismissing an employee and they have a disability, there is the need to consider the issue of proportionality. So whether it is a proportionate step to dismiss the employee. And that's a similar test as dealing with unfair dismissals and reasonableness. And I'll go on to talk about that in a minute. So looking first at when a sick employee is disabled, the first step is going to be to assess if there is an underlying medical condition. If there isn't such a condition, then as most of you are aware, if it's lasted long enough and has a substantial effect on normal day-to-day activities, it may amount to a disability. So the statutory test is there on the slide, a physical or mental impairment with a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Long-term in this context means lasted for 12 months or likely to last for 12 months. So the focus needs to be on the likely prognosis if somebody has had a condition which has not lasted for 12 months, because clearly it may well project beyond that 12-month point and then fall into the realms of potentially being a disability. In terms of the impact on normal day-to-day activities, we know that a substantial adverse impact is actually not that high a bar, higher threshold to achieve. It means more than minor or trivial, so clearly the impact does not need to be that significant. And impact on normal day-to-day activities includes everything from activities at home, washing, dressing, shopping, driving, all those sorts of activities, to activities that were in the workplace also. So in making this assessment, it may well be necessary or certainly prudent to obtain a medical report. In particular, occupational health will be able to advise you on the type of adjustments which you could make to the employee's role, and they have a really valuable role there. But one very important point to make here is that it's not for the medic or for occupational health to say whether the employee is disabled. Whilst they may give a view on that, it's important that you as the employer make your own assessment of whether an employee is disabled, as ultimately the buck stops with you in terms of your duties and responsibilities as an employer. And I have seen cases where occupational health or a medic have said, in my view, this employee is not protected by the Equality Act. But actually, when we've gone on to look at it, the likelihood is that the employee is, and they've gone on to raise complaints on that basis. So it's important that you interrogate the information for yourself and not just rely on the opinion of occupational health. What occupational health or the medic can helpfully do is assess and look at the impact on day-to-day activities and in the workplace, and from that you can then carry out your assessment of whether or not the statutory test has been met. obviously with or without the help of your friendly gunnercooke lawyer. Important to note that some conditions are automatically recognised as disabilities, cancer, HIV, MS. And one approach which you could take, and which I sometimes advocate, is when it's not clear, if you have a borderline case, as to whether or not someone is disabled, because quite often it won't be clear, and quite often only a tribunal could determine it. Proceed on the basis that they are disabled. So if you do that, it means you would need to consider reasonable adjustments, etc. You would need to consider proportionality in any dismissal. But often these things also should be considered as part of a fair procedure and a reasonable procedure. It might be arguable that the threshold is slightly higher in terms of what you need to do under discrimination law from what you need to do in terms of a fair dismissal. But it certainly doesn't do any harm in achieving a fair dismissal to follow the same type of steps. And of course, then it would also protect you if the employee alleges that they are disabled, and they can then go on to prove that that is the case. So, what steps should you take to minimise the risk of disability discrimination claims arising from ill health dismissals? The first thing I want to talk about is reasonable adjustments. So, as I think most of you will know, there's a duty to make reasonable adjustments where an employee is placed at a substantial disadvantage by a provision, criterion or practice operated by the employers. This could be anything really to do with their working environment, any policy or procedure. It could be the physical arrangements at the premises themselves. It could be their duties. It could be KPIs. So provision, criterion and practice is a wide-ranging concept. But the key is that you're only required to make reasonable adjustments if there is a substantial disadvantage. So if the employee is not disadvantaged, then there's no requirement to make adjustments. There's no blanket duty if you have a disabled employee to do that. So the first thing really would be to talk to the employee about whether or not they are disadvantaged. And in the context of someone who's on long-term ill health absence or has intermittent absences due to ill health, obviously it's about looking at whether there are any steps you can take which would enable that employee to return to the workplace or to enable that employee to have more consistent attendance at work. So possible steps include allocating some of the disabled person's duties to another, transferring the disabled person to fill an existing vacancy, allowing for periods of absence for rehabilitation, assessments or treatment. And the final one I've got on the slide here is modifying absence management procedures. And I should say, clearly this list is not exhaustive. There are many possible reasonable adjustments which can be made, and there's useful guidance on this provided by the EHRC, for example, and also ACAS. So the last point, I've highlighted the case of Griffiths and Department for Work and Pensions, and it's on the very, very tricky issue of whether or not there's a requirement to make reasonable adjustments to trigger points for warnings under absence management policies. This has been considered by the EAT in a number of cases, but most recently in Griffiths and DWP. And the case established that where you have trigger points under an absence management procedure, or you have disciplinary warnings related to poor attendance, then the duty to make reasonable adjustments is triggered. Now that doesn't mean to say that you always have to make adjustments, it just means that the duty comes into play. There's then a separate question of whether it's reasonable to actually make an adjustment. So for example, it may not be a reasonable adjustment to discount disability-related sickness absences altogether when you're looking at whether or not someone meets the trigger points under a absence management policy. As clearly, if you do that, it would defeat the purpose of having an absence management policy in the first place. And in a way, it would simply allow the employee to remain off work or to have a high degree of absence. However, it may be a reasonable adjustment to discount a certain level of disability-related absence under the trigger points of a formal process. There aren't any hard and fast rules here. I can't tell you what would constitute a reasonable adjustment, as I'm sure you'll appreciate. What you would need to do is apply your mind as to whether a certain level of disability-related absence can be tolerated, and also whether tolerating that level of absence would actually make any difference. So it's all very well to say we'll tolerate this certain level of absence, but if the employee is never going to be able to go anywhere toward near achieving that level of absence, then it may not make any difference anyway. When you're looking at what you tolerate, you also need to take into account the impact of the absence on the business. What I think is clear is that the level of absence that could be tolerated should not be arbitrary and should be based on business needs, and also taking into account likely absence levels from the employee and what would be reasonable to expect from the employee in terms of disability-related absences. So a very tricky area, and I think it's one where you just have to look at it on a case-by-case basis in making an assessment of whether you need to discount disability-related absence. So just some key points on reasonable adjustments. The first one is that you can and absolutely should ask the employee what they think is needed, if they think they're being disadvantaged, and if so, what they think would remove that disadvantage. But ultimately, if you draw a blank there, the onus is on you to identify adjustments and to think in some sense creatively about what you could do. I have seen cases where an employer hasn't addressed their mind properly to adjustments and hasn't considered it, and then you get to tribunal and the employee's representative will give a whole host of adjustments which it says the employer could have made, and it isn't a defence to say, well, why didn't the employee raise these at the time, as ultimately the onus is on the employer to identify the adjustments. Occupational health can be very helpful, as I say, with identifying adjustments. Ultimately, that's what they're qualified to do and specialised in, is looking at how health issues can be accommodated in the workplace. As I've mentioned already, you need to look at how practical the step is, and also will it alleviate the disadvantage caused. If it won't alleviate the disadvantage, for example, with the trigger point example that I gave, then there would be no point in actually removing or changing the trigger point. If you don't think that an arrangement bit will work, then it's important to be able to document the reasons why. So you've got your paper trail in place. But I do think it's important to be prepared to trial an arrangement, even if you are sceptical as to whether or not it will work and as to whether there's any benefit there. Finally, just looking at claims for discrimination arising from a disability. So this is the other main claim which I am seeing is being made, where a disabled employee is dismissed due to ill health. And the basis for this type of claim is that the dismissal is unfavourable treatment arising from their disability and is therefore discriminatory. The legal test being, has the employee been treated unfavourably because of something in connection with their disability, and a dismissal for ill health is clearly in connection with their disability. So in this situation where you have got an ill health dismissal and the employee is disabled, the onus will be on the employer to show that the dismissal was a proportionate means of achieving a legitimate aim. Now, it's likely to be a legitimate aim to have an employee in the job who can perform the role, etc. So the legitimate aim side of the test is likely to be easy to satisfy, and it comes down to proportionality, was dismissing the employee a proportionate response to achieve that legitimate aim. And that really is about looking at, well, if the objective is to have the employee in the role, has everything been done to achieve that? Could other steps have been taken before reaching the decision to dismiss? Because you needed to have someone who could perform the job. The recent case, which I've already mentioned, of O'Brien and Bolton St Catherine Academy, gave some useful guidance on the proportionality test, as Ms O'Brien not only claimed unfair dismissal, but also that she'd been discriminated against because of her, she'd been discriminated against as it was discrimination arising from her disability. And very helpfully to employers, the judge commented that the test for unfair dismissal is broadly the same as the test for assessing proportionality. What he said is that it would be a pity if there was any real distinction in the context of dismissal for long-term sickness, where the employee is disabled within the meaning of the 2010 Act. The law is complicated enough without parties and tribunals having routinely to judge the dismissal of such an employee by one standard for the purpose of an unfair dismissal claim and by a different standard for the purpose of discrimination law. Fortunately, I see no reason why this should be so. So, to summarise the judgment, the Court of Appeal doubted very much whether the two tests should lead to different results in this context. So an employer whose response is found to be disproportionate and discriminatory is very likely to also be found to have acted unreasonably in dismissing the employee, and vice versa. In relation to both tests, it's important to consider factors such as the impact of the absence, the reasonableness of waiting longer for the employee to return, the duration of the absence to date, and the evidence as to when the employee may return. So all of these factors are equally relevant to proportionality in the context of a discrimination claim. Obviously, as we've already discussed, before reaching that decision to dismiss, one of the factors which would be taken into account is whether reasonable adjustments can be made. And whilst they are separate legal claims, I think that this is a factor which a tribunal would still look at. In all likelihood, it may well be that an employee would in any event bring a separate claim in relation to reasonable adjustments if it was claimed that reasonable adjustments could be made. So I think this case does provide very helpful guidance. It is the first case I've seen that has seen that the tests are broadly the same. So I think in that context it is departing slightly from previous views that the discrimination test was a higher bar than the unfair dismissal test. But in my view, if you follow the approach adopted here and consider the kind of factors which are recommended, then it will help to stand you in good stead in being able to show that a dismissal of a disabled employee is not only fair but also a proportionate response in the circumstances. So, just to draw some conclusions, firstly, when you're looking at short-term intermittent absences, it's important to identify what approach you're going to take, what line of process you're going to follow. Is it capability, conduct, or is it SOSR? As I've explained already, if you do get it wrong, there can be implications in terms of being able to show it's a fair dismissal. If you have got an employee who has an underlying medical condition, then it's important not to turn a blind eye to it just because that isn't explicit, and to carry out your own assessment of whether that employee may have a disability. Really important, also linking into point 2, is to ensure there is consultation with the employee throughout the process, so that you can gain as much information as possible about whether or not there could be any form of underlying condition, and so that you can assess the genuineness of the absence, for example. As we've heard from the O'Brien case, do not underestimate the importance of up-to-date medical evidence. It's always going to be risky to rely on a medical report that is not up to date as at the date of dismissal. If you are going to do that, you should at least have the employee's agreement that the report represents the up-to-date position and that nothing has changed since the last medical report. And finally, and as I'm sure I don't need to tell an audience of mainly HR practitioners, make sure you follow your own policies and procedures, and of course the ACAS code when you're dealing with conduct issues. Okay, well that was all I was going to talk about today. I'm not sure if we have any questions. It doesn't look like we have any questions, so I must have given a very comprehensive talk. Hopefully I've kept everyone's interest. If you do have any follow-up questions, then please do feel free to send them through to us. I believe my contact details were on the first slide. It's jo.tindall@gunnercooke.com. We'll also be emailing out the presentation, I believe, to all attendees, so that you'll have a copy of that for future reference. Please do feel free to give us feedback. It's always very helpful. If there are any topics you'd like to see covered in future people hour sessions, then please do let us know. In this session, we've tried to focus on something helpful for practitioners rather than an employment law update. So I do hope you found it useful, and if you think it would be helpful to cover any other topics in this way, then please do let us know so we can take that into account for future sessions. So thank you very much for attending today, and enjoy the rest of your day. Thank you.